Thank you everyone for being here. My name is Sophia Steele and I'm the Government Affairs Manager for ABC Western Washington. Thank you for joining our webinar, The Construction, Lien, and Bond Claims in Washington, How to Get Paid. Let me now introduce our presenter today, Ryan. Ryan is a member at Ahlers Cressman Sleight PLLC, where he focuses his practice on representing owners, property managers, developers, general contractors, subcontractors, and suppliers in construction and real estate matters. He's also a member of ABC's Legal Action Committee. With that, I'll turn it over to you, Ryan, and let you get started.
Okay, good afternoon, everybody. Thank you for having me today, Sophia. Today, we are going to talk about construction lien and bond claims in Washington. And I've tried to include quite a bit of material here in the seminar. So I hope to get through all that. I'll be moving at a brisk pace, but we can certainly cover questions at the end. So the main thing I want to cover today is, what does a contractor do to make sure they get paid on a project? And well, there are often contract provisions in place. Second to that, in terms of securing the right to payment, there is the protection for lien and bond claims. And in asking what sort of lien rights and what sort of bond rights a contractor or subcontractor or supplier might have on a job, or a design professional, there's two preliminary questions that you first want to answer. The first is whether the project is a public or private job. And the second question that you want to ask is, if it is a public, is it a state or federal project? Today, we are going to cover, in terms of public projects, limited to Washington State Public Works projects. I briefly mentioned what happens on a federal project in some of these slides here. You'll see in this next slide, this is kind of a flow chart in terms of the questions that should be asked with respect to payment rights and what body of law you might be under. But generally speaking, I think the largest percentage of the ABC members, if they're working on public jobs, are dealing with Washington State Public Works and not federal jobs. And if you are on a federal job, it implicates a whole separate set of statutes, something called the Miller Act, the Federal Prompt Pay Act. I'm gonna briefly touch on those so you're aware they exist, but not cover those in a ton of detail today. We're going to start by talking about liens on private works construction projects. That's your typical project that is owned by any private owner that is not a public body. The first question I need to ask here is, who has a right to potentially file a lien on a private job? And basically, any general contractor, supplier, architect, engineer who has, per the statute, furnished labor, materials, service, or equipment used in improving private real property is potentially going to have a right to assert a claim of lien. The statutes, as well as the case law, go on to define as what could be labor, what is materials. And typically materials have to be something that becomes part of the physical structure. It may not include, and often there's not necessarily a clear answer in the statute or necessarily the case law, but for instance, materials which do not become part of the work, for instance, furnishing something like blasting powder used to take down a building, debatably may not be lienable. In another portion of the statute, it must be furnished at the request of the owner or the owner's actual agent. Labor generally has to become part of the improvement. Labor performed before delivery is not lienable. For instance, if you were in a steel shop, the labor if you separately charge the labor in cutting the steel, it may not be lienable. This does not mean, I have not many times seen steel suppliers either bump this into the material cost, where they may certainly have a much stronger ability to maintain the claim of lien, or even when they segregate their labor costs, the cutting fees, try to lien for that, and oftentimes, though the fact that they may have problems taking a lien like that all the way through foreclosure doesn't prevent people from filing liens, but it's something to be aware of is that they're, not necessarily everything that gets liened for in this state creates a right to lien. The types of activities that could create a right to lien are demolition, any sort of construction, repairs to buildings, landscaping, any sort of professional services provided by licensed professionals, any sort of condominium improvements. There's, even though the statutes don't necessarily always set this forth clearly, items such as environmental remediation, where materials are, such as bad soil is simply being removed from the project, may not be subject to a lien. Architectural services for a building that's never been built probably is not lienable. I have the next slide here is a chart which the lawyers call the chain of privity, describes generally how people contract on a construction project. You can see here that an owner hires the general contractor, who can hire suppliers, can hire laborers, subcontractors, and each subcontractor, as they go down, can potentially hire, suppliers or subcontractors or their own laborers. And the reason it's important to understand this chain of privity, in the difference between a first tier and a second tier subcontractor, is because under the lien statutes, it can impact whether you have a right to claim a lien, whether a pre-lien notice is required. And thus I always found it helpful to include this slide, which shows how you can be several rungs down and may need to provide a different lien notice. Something we touched on a moment ago is that whether you can lien may depend on what is provided. Here's the example of a blasting powder to a clearing sub may not be lienable, whereas very clearly when a material supplier, if they've given the required pre-lien notice, can lien for the lumber or roofing, shingles, or windows or doors. One limitation in the statute is that the lien must be provided at the request of the construction agent of the owner or the actual owner. And then where this language can end up mattering, for instance, is the statutes and case law indicate that when you don't maintain a valid license, for instance, you can be a licensed subcontractor, but if you contract with a developer who, say, is acting as a general contractor, but he really shouldn't be without a license, there's a potential for your lien to be compromised if the entity who was upstream from you hasn't maintained the license. It may affect your downstream ability as a subcontractor or supplier ability to maintain a lien. And following that, unlicensed and unregistered entities cannot lien themselves. Presuming that a contractor is entitled to lien, the most, basic thing to know here is that a claim of lien must be actually recorded with the office of the county recorder where the work is performed within 90 days of the last day of work. This is viewed as a strict deadline, a statute of limitations. If you're a subcontractor and the general contractor's making excuses on payment, dragging you on, it may be because they're trying to get past those 90 days and they want to prevent you from filing a lien. So be aware that is a strict deadline in terms of actually recording the lien. Separate from that, if the entity, a subcontractor, a general contractor, or supplier wants to bring an attorney's fee claim against the owner, they must serve the copy of the claim of lien via certified mail on the owner within 14 days. So it's another procedural requirement. The failure to do this shouldn't affect the validity of the lien, but it absolutely will affect the ability to claim attorney's fees in a foreclosure proceeding against the owner. Next, this to depict what exactly I just described here, we're dealing with a project start date here, of January 1, and the last day of labor materials might be 6 years later on a major public works project, like something, or a major private project, something like the some major skyscraper being built, you must file your claim of lien within 90 days. Punch list generally will be viewed as extending the 90-day period, although warranty work does not, and perhaps there's some gray area on what is punch list and what is warranty work at times. The contents of the claim of lien are set forth in the statute. You got to include the name of the liening party, first and last date of work, the entity with whom the claim contracted with, and you have to include a description of the property and the amount for which the lien is claimed. And a sample of what this looks like based upon the statutes found in the next couple slides here. Now to the pre-lien notice, which often can be a confusing area for particularly those operating below the general contractor. Oftentimes, notice to owners will be required as a general rule. It's not going to be required of the general or a first tier sub. But once you get down to lower tiers, you're going to need to serve the notice to owner. This is a notice that is served at the beginning of the job. Residential project needs to be served within 10 days of the first work or delivery of material. Commercial projects, it will relate back 60 days if you want to protect your right to payment on everything. And then the last bullet there where it says it's not required of laborers or those who contract directly with the owner or the owner's agent. That's where I say first tier subs generally are not required to give this pre-lien notice in order to maintain their lien rights. This pre-lien notice to owner generally has to go to both the owner and the general contractor. If you don't send this, it can result in forfeiture of the lien rights. Back to the concept I was discussing a moment ago on a commercial project, the pre-lien notice only protects payment rights back 60 days, meaning if there was a first delivery that went back, for instance, as shown on this chart here, you can see my cursor here, and the pre-claim notice was not sent until after the 5th delivery. The supplier in this instance is going to lose protection of its first and second delivery because the 60 days does not relate back far enough. And if you're dealing with substantial dollars, these are the type of things that a lien claimant and a project owner could be fighting over in court. A residential project, the relation back protection is much more limited. Under this example shown on this slide, the first, second, and even the third delivery are not going to be covered because the pre-claim notice was given too late. Thus, if you're a supplier, you want to make sure to give these as soon as possible, give them properly, otherwise it potentially compromises your ability to get paid. This is what the statutory notice to owner looks like. It's pretty simple. You put it in the mail, say we may lien your property, and if required, it'll protect your right to maintain a lien. There's a separate notice for professional service providers, which will protect their rights against certain parties. There are not a ton of professional service providers who are ABC members, but it's important to notice that if anybody is perhaps in that line of work, that there's a separate notice from professional service providers that should be provided. I think perhaps one of the more important things to distinguish here, and I think probably many ABC members are in a world where there's a separate notice, separate from the notice to owner, that many are not aware exists, that has to be required in some instances. And that is a document called the Notice to Customer. It's found under a separate statute, the Contractors Registration Statute. And generally speaking, on any residential project where the general contractor is contracting directly with the owner, a notice to customer, which is, as I indicated, a separate form, needs to be signed and sent to the, or signed and a copy given to the customer and maintained in the contractor's file. And if that's not maintained on the residential job, there is going to be no right to lien. And similarly, on commercial jobs of $60,000 or less, the same notice to customer needs to be signed. So any contractors working directly for the owner on small commercial jobs need to get this form signed. Otherwise, they could have a problem in not providing this. It generally only applies to 4 or fewer residential units, and does not apply to contracts of less than $1,000, which is as the years go on, the statute hasn't changed, a progressively small amount for a limitation compared to 30 years ago, when I think the $1,000 minimum limit was set, that almost no job other than handyman work would fall below that level. So this slide just covers those dollar figure limits that I just talked about. Here's a sample of what the notice looks like here, and it has to actually be signed by the customer with the contractor's name on it. In addition, contractors should be aware that there is a special rule on residential remodels to make things even a bit more complicated, and that is that generally there's all sorts of language in the statute. The most generalized reading of it is that first-tier subcontractors who do not have to give the notice to owner, that's the certified mail notice, on other types of jobs, must give the notice to owner if they're working on an owner-occupied residential remodel. The amount of the claim lien can often be a source of confusion. How much can we lien for? Can we lien for extra work? And as a general rule of thumb, what the statute says is you have a lien for the contract price, and if there's valid change orders under a contract which aren't paid, you can also include those. Under Washington law, you'll typically be able to claim 12% interest on top of that, unless the amount was modified per contract. And one more special rule for owner-occupied residential remodels is that there is some protection for the owner, and that they can only be subject to a lien for amounts they have not already paid the general contractor when served the notice to the owner. So there is, so it's limited to the amount of the general contract that the owner has on those owner-occupied residential jobs. Once a lien is recorded, which, as I mentioned before, it had to be recorded 90 days from the last day of on-site work by the contractor, there's expedited procedures to commence a lawsuit to foreclose these. The lawsuit must be commenced within 8 months, which is relatively quick when most contract claims can be filed up to 6 years later. The statute further indicates that the lawsuit must be tried within 2 years, which, even though cases are set for trial sooner than that, or under the current case schedule in most of the counties around here, the statute does set a requirement to be tried within 2 years. Payment is made upon foreclosure. So the effective date of lien filing, this is similar to another slide we had a moment back here, but this depicts where you start work on January 3rd. The advantage of this lien is the lien's generally going to tie to the contractor's first day of work, meaning that in this example where the construction financing did not come until later on in the process, this creates a situation where the contractor could have a right to foreclose this property and extinguish the construction loan, which can create a ton of leverage for the contractor in trying to get paid. Thus, this articulates the power of a construction lien. If a construction lender has the potential to get wiped out by the contractor, they're going to find a way to make sure the contractor gets money. Most sophisticated construction lenders these days will find a way to make sure this doesn't occur. If they know work has started on the job before financing, they will go and ask for a subordination agreement, asking the contractor to sign it. But I have had instances where lenders have not done this, and the pressure you're able to put on the lender by naming them in a lawsuit saying we're going to wipe out your deed of trust if you don't pay us is significant enough to get the contractor paid. So to summarize what you've got to do on private liens to maintain your lien rights, if a professional services provider can record their professional service provider notice, if a notice to customers has to be signed, that's for the contractors to directly contract with the owner, that needs to get signed. The notice to owner is potentially the third step that needs to be complied with, serving that via certified mail. Then you record the lien within 90 days of the last day of work. You serve it on the owner within 14 days, and then you call up your lawyer to go ahead and to commence the foreclosure lawsuit. So while there's a lot of tricks and traps in all these notices, I think a general rule of thumb is be overly cautious in providing the pre-lien notices and follow the steps to protect your payment rights, because sometimes it is the only way you can get paid. And you know, looking back on my career, it seemed you know, particularly we saw a crash back in 2009, the Great Recession. You know, liens were perhaps the only security a contractor had. Unfortunately, at that time, property values had dropped so much, so it at times limited the value of the lien. If construction lenders went and foreclosed, in addition to the construction lien claimant foreclosing, they could wipe out the subordinate construction liens. But you know, other than instances such as that, I mean, it can be a very valuable payment right, and it sometimes when, you know, when the owner's gone belly up, it can otherwise be the only way you can get paid. Additionally, the general contractor should be aware there is a statutory requirement to post lien information, the property address, legal description, and so on, the owner information on the job site. I've never heard of any instances of contractors getting in trouble for this, but it is required. You should also be aware for general contractors, and this applies to owners as well, that if you disagree with the amount of the lien claim, you always have the option of obtaining what is known as a lien release bond, and it's a device set forth in statute. And what is required is that you go to a surety who will essentially provide a payment guarantee that is recorded in the public records with the county recorder, that says they will pay up to 1.5 times the amount of the lien to remove from the property. And this can be a big deal if you know, owners are looking to sell, or from a general contractor standpoint, if a owner is looking to a general contractor for indemnity, they will you know, often say, hey, general contractor, get rid of your subcontractor's lien. So the ability to obtain a lien release bond can be a very valuable tool to get rid of problematic lien claims. And once that occurs, the lien claimant's rights are to foreclose against the payment bond that has been recorded. I want to distinguish these sorts of lien release bonds from the other types of bonds you'll see on private works. You will see private payment bonds, which I don't cover in detail here today, but that's potentially another payment device for contractors to make claim against. An example of that might be if on, you know, particularly bigger jobs, it could be a big public job, a general contractor may want to have a very strong assurance that a sub is going to pay everybody all of its sub tiers, and thus will require a private payment bond similar to the one a general contractor has to obtain on a public works project. And that's simply a creature of contract. It's not required by statute. So you will see those on jobs, and that's distinguished from what we cover today. There's also private performance bonds, where similarly a private owner or a private general contractor could require the parties with whom they're contracting to obtain a performance guarantee to assure that, which, you know, essentially operates as a surety guaranteeing that if the contractor defaults or goes out of business, the surety will actually complete the work. And then also distinguish that from the contractor's registration bonds, which are those $6,000 or $12,000 bonds that all contractors need to have to provide a very minimal amount of payment security. So these lien release bonds are different, but I think it's helpful to briefly touch on these other types of bonds you do see on both public and private construction jobs. Another payment device contractors should be aware of is the ability to issue what is called a stop notice to the lender. That is, it's also found in the lien statute. And what this device does is typically used by, I would say, subcontractors most often, who are somewhat disconnected from the lender, and they are authorized to send, if they have not been paid as required by their contractors. It has to be within 5 days after the failure of payment, no more than 35 days, issue a notice to the lender saying, lender, we have not been paid. If you go ahead and disperse money to the owner or general contractor without paying us, then we can, the statute says that they can be jumped in lien priority, which, as we touched on a moment ago, that's a big deal. It will basically, in most instances, freeze funding on the project till the problem is resolved. It's I would say, a much less used device than construction liens, but I think contractors should be aware of it, that it exists, and you potentially have that right. Like I said, most often I think it's subs who can use this to their great advantage of seeing that they get paid without even, most often without even having to file a construction lien. There's statutory content to the notice, which sets forth the name of the involved parties, the amount owed. And here's a copy of what the form looks like. Again, set forth by statute. When on that happy day when you actually get paid in response to your lien, I would say releasing it is much, much simpler. It just effectively gets recorded in the same public records where you recorded the claim of lien. It gets recorded over the top of the lien. And the next slide here shows a simple sample of what a release of lien form can look like. There's no particular magic to it. Where it can get a little tricky, and you probably want to have your lawyers prepare them for you, is when you are partially releasing a claim of lien in response to a partial payment, or if you were releasing certain parcels, if one parcel was paid but others weren't. If it's something less than a complete and full release, you want to be mindful of this and make sure you know what you're doing in releasing it. Contractors should also be mindful that there is a procedure to obtain the expedited release of liens in this state. It's called informally called the frivolous lien statute. It's within RCW Chapter 6004. This could perhaps appropriately be utilized in a situation, for instance, if a contractor did not get that signed notice to the customer and it were required. There's really, subject to creative arguments, there's no basis to maintain a lien, and an owner could utilize this statute. So, contractors want to be sure to do their claims correctly, not to file claims with their question, or seek legal advice if they do have questions whether they can maintain their claim of lien. I will say the frivolous lien statute has some, relatively significant burdens, or the statute, when read in conjunction with the case law. Thus, contractors, it has to be usually a pretty egregious example of not being a valid claim of lien before it will make sense to go challenge it under that statute, simply because if you don't win a motion to release the lien, the owner or general contractor moving to release the lien could be subjected to an adverse claim for attorney's fees and costs. This next slide here kind of puts it all one place, which might be a nice reference for everybody, a summary of the various requirements, the types of notices that could be required, including the special rules that apply for the owner-occupied residential remodels, or the notice to real property lender. I would not rely on this as it's one sheet kind of summarizing everything. It applies to most lien claimants. I think there's always a potential for gray area or interpretation. As clear as they perhaps tried to make the lien statute, it seems to have still bred plenty of litigation over the last close to, or approximately 30 years since it's been enacted, or Washington's current version of the lien statute was enacted. Now we're gonna move on to Washington State Public Works bond and retention claims. And what we're talking about when we talk about the public works bond and the retention claims, it is essentially two separate statutes that protect the payment rights of, for the most part, lower tier subs, let me restate that, entities other than the general contractor. It protects subcontractors, suppliers downstream. There's the Retainage Act and the bond statute, RCW 3908. The general contractor does not have payment protection on public works jobs the same as on private jobs where they can directly file a lien claim. I think some of the policy behind that is the creditworthiness of the owners, the public owners, meaning that the judgment against a public owner presumptively is likely to be good no matter what. There's not the need for the same payment protection, and there's also prompt payment law. And again, I note on the last bullet there, distinguish this from federal public works job, anything you're doing from the federal government, or a job, say, that might be down at Joint Base Lewis McChord, the Army down there, or the Air Force. Those types of jobs are going to be subject to the separate Miller Act, which we don't cover today. This slide again touches on the fact that general contractors don't have comparable payment protection, and they seem to live with it. It's profitable enough doing these federal or these state and federal public works jobs. They don't need the private liens. It's not the same as not the same risk that a private owner that a public owner won't pay. First, digging into the first of the two statutes, the retention and the bond claim statute. We'll cover the retention here. What the retention is it's generally the 5% that is held back from the general contract that is in turn held back from the each subcontract, and often the lower tier contracts as they go down. This is mandated by statute on public works job. Virtually any tier of subcontractor or supplier who has filed a proper notice of claim can maintain a claim against the retention, except that suppliers who supply materials to other suppliers generally are not going to have a claim against the retention. This is covered in case law. As I just mentioned, 5% is the typical amount that is held back from the general contractor. It gives the public owner protection in the event they don't pay the people downstream or the entities downstream. Most sophisticated generals, or I would also say all generals and many sophisticated subs, in turn withhold the same 5% downstream from their own sub tiers. Oftentimes by the time you get to suppliers, they may not be quite as willing to accept that, so that's a product of negotiation and contract. Generally, sub-tier subcontractors and suppliers must give a notice within 60 days of supplying materials or equipment, which relates back 60 days. But that's not necessarily required for everybody else. All retention fund claimants must provide the public works owner notice of their claim within 45 days after completion of the contract. And this is tricky because it is not necessarily the same thing as the bond statute, which refers to the act of acceptance. The claim must then be foreclosed within 4 months after you've given your notice, and the recovery on the retention is limited to the amount in the retention fund. There's relatively broad coverage on the bond claim as well. It covers persons or entities who supply labor, materials, or equipment and further into the contract. It has slightly different rules. It doesn't necessarily have to be incorporated into the project the same as on the private works jobs. It's just different statutory language we're dealing with. The pre-claim notice, sub-tier subcontractors and suppliers of material and equipment must give notice within 10 days of first providing their supplies or equipment to the project. And then for the bond claim, all claimants must, within 30 days after formal acceptance by the public body, file with the public works owner a notice of claim. The bond claim lasts much longer than the retention claim, which has to be foreclosed within 4 months of your notice. The bond claim lasts at least 3 years for an oral contract, and perhaps 6 years based upon a written contract. It depends which statute of limitations were applied and the exact nature of the relationship of the party who is making the claim. So to kind of summarize these competing requirements, the pre-claim notice requirements for suppliers are different under these two statutes. The claim has to be filed within 30 days of acceptance for the bond or 45 days of completion for the retention claim. The retention claim has to be foreclosed much more quickly, and both the statutes give you a potential claim to attorney's fees. When, as a practical matter, in enforcing these or in asserting payment protection rights for clients, what we will do is try to combine the rules together so that one notice can comply with all the rules here. So if you need to give a pre-claim notice, you'll want to give it as a supplier within 10 days of your first delivery. You'll serve the combined claim of lien within 30 days of completion of the work, and then you'll want to foreclose the lien within 4 months thereafter. The copy of here, the next slide here is a standard one form of what a notice of claim against the retained percentage and bond looks like here. It references both. It's a single form which references both statutes. We'll typically be sending these on behalf of subcontractors or suppliers and addressed to the public works owner and copied to the general contractor and bonding company. And it's this certified mailing that will need to be sent. You send this, it protects your payment rights, and it's a essential procedural step in asserting those rights. And here's what the pre-claim notice looks like. And here's a sample form if needed. And again, a summary chart of what the requirements are for each of these. And as I said, it's really most efficient to combine them together. Particularly first tier subs working on a job that's going to be make the most sense. There's enough at stake to just go to your lawyers and make sure they've done this right or giving you specific advice. What notices are required on your jobs, and make sure things are done correctly. The next topic I'd like to touch on here is Washington's Prompt Payment Act, and this is generally applicable only to public jobs and not private jobs, but it's really an additional payment protection device here, and it's about the only thing that protects a general contractor for those ABC members working as general contractors on public jobs who don't have any payment protection. General contractors are entitled by the Prompt Pay Act to receive payment within 30 days after receipt of the invoice by the public body. If there's a dispute, the amount of the withholding is limited to 150% of the amount that is in dispute. Payment on the retainage is required within 60 days of completion of the contract work, and that's subject to there being any outstanding subcontractor or supplier retention claims. There's 1% monthly interest entitlement in the statute, as well as attorney's fees for a public owner that breaches these provisions of the Prompt Payment Act. So the general contractor does have some additional moves available to press public owners for payment who are wrongfully refusing to pay. Although, usually public owners, when they're withholding, most often have a reasonably good reason. Perhaps they're not quite as, holding the purse strings on the public coffers quite as tight as some of the private owners do, or don't come up with invalid reasons for non-payment as often as we might see from private owners. They usually pretty well thought out, and even if in dispute, is more justified than you might see on some public or on some private jobs. Subcontractors are also entitled to prompt payment protection on public works jobs. Similarly, if there is a dispute, they can only withhold 150% of the amount in dispute. The subcontractors must be paid within 10 days after the general contractor receives payment from an owner. If a general fails to do this, the general's opening themselves up to liability similarly. So if further, the statute continues that if a general contractor does want to withhold money, they've got to detail why payment is being withheld, what remedial actions must be taken to receive the payment on the withheld amount. These are statutory requirements. And the general contractor can subject itself to these same 1% per month interest and attorney's fees if it fails to comply with the statute. So there's certainly been instances where I've represented subcontractors on public works jobs, and we've asserted violations of the statute and asserted these, additional interest rights and attorney's fee rights against the general contractor. Another important aspect of payment to be aware of on both public and private works jobs is payment clauses and how they are used in the state of Washington. Most often, I would say general contractors, particularly sophisticated general contractors, will try to use a pay if paid clause. And I'm going to distinguish here a pay if paid versus a pay when paid clause. And what a pay when paid clause is it says something typically to the effect of the subcontractor shall be paid to the extent contractor has received payment from the owner for the work. And this is pretty, it says that payment will only be made when the owner makes payment, but based upon Washington case law, this is not strong enough language to absolutely relieve the general contractor from its payment obligations if the owner does not pay. It's interpreted to delay payment for a reasonable time, and it's interpreted as a pay when paid clause. The other type of clause to be aware of that is much more problematic for subcontractors, and on the other hand, for those ABC members that are general contractors, is what is referred to as a pay if paid clause. And I've put a sample of such a clause here. And the courts say that if a general contractor wants to be protected from paying its sub if it is not paid by the project owner, it needs to include language such as indicated here, that payment to the subcontractor is absolutely conditioned upon payment from the owner. And when that sort of language is clearly stated in the contract, courts generally will state, yep, this provides protection to the general contractor that they do not need to pay the subcontractor if payment is not received by the from the owner by the general contractor. These sorts of clauses, I would say, is particularly on larger jobs. It is perhaps I would say certainly more common than not for subcontractors to accept this sort of language, and if subcontractors do accept this sort of clear pay if paid language, I would say be exceptionally mindful of your lien rights, your bond and retention rights, which those rights may be watered down somewhat by the pay if paid, but it gives another avenue to make sure you get paid. But oftentimes generals will be unwilling to negotiate this language out. And you could certainly try as a subcontractor, but I've seen in many instances that generals insist upon using this sort of pay if paid language. And so generals proceed at your own risk because that's a potential problem, or sorry, subcontractors proceed at your own risk. That's a real problem if an owner is withholding payment from the general contractor and you as a subcontractor are not going to get paid because of it. The last subject I want to touch on here is just the concept of lien waivers and releases that are often seen on both public and private works jobs. in the state of Washington. If you're a general contractor, you'll generally, want to have a pretty decent both conditional and unconditional lien waiver form as part of the contract. I think what, the advice to both generals, if they're signing these for the owners, or subcontractors signing these for the general contractors, is yes, it's appropriate to give a partial conditional waiver of lien rights upon payment. But for instance, this form does not easily have a spot for a contractor to include any sort of exempt items, such as pending change orders that are going through being processed. And if I were a subcontractor would come to me to say, hey, the general contractor says we need to sign this form here, but we've got 4 outstanding change orders they haven't commented on. What we would do is we'd come up with language to insert here to say, yes, we release our rights, but we reserve rights on those 4 outstanding change orders, because if a subcontractor or a general contractor is simply signing these forms to get money, but is not properly reserving issues which are not subject to the payment, it absolutely creates a situation where it could be an absolute and complete waiver of the right to payment. You could go ahead and file the lien claim down the road, and the owner or the general contractor will swoop in and file a summary judgment motion saying, hey, you don't get paid. You filed this lien waiver as of a date 4 months ago on the project, or they'll seek to somehow reduce the claim of lien. So everybody should be very mindful of these documents that are being signed in order to elicit payment on projects, because they do result in waivers of rights. And I've been involved in a handful of battles over the years where whether it's general contractors or subcontractors have been left in problematic situation because they sign these forms without thinking much about them. You'll also see these forms often in perhaps combined with pay applications, and certainly read what you're signing and reserve your rights where necessary. Again, to coming to a conclusion here, I want to make it clear we've covered the main payment protection devices that you see, I would say 95+% of the time on Washington jobs, or that impact ABC members. But there are other types of payment protection you will see. Miller Act bond claims, which are the federal works projects we covered previously, as well as private payment and performance bond claims, which really are a creature of contract, where a general will require them from a sub, or a private owner will require a payment bond from a general contractor. I recently saw one of these on a private apartment project, which for various reasons the general contractor had was required by the owner to obtain payment bonds, because the owner wanted to see that there was no liens on the job. So you do see these different rules would apply to bringing claims against those types of security devices, and just be aware that they may exist, so you can perhaps recognize what you're dealing with, or if you're uncertain, seek legal advice where needed. Sophia, I'm not sure if I see any questions in the chat here, but if there were any questions, I could certainly answer them. I think we've covered what I was looking to cover here today, and thanks for having me.
Thank you so much. That was a ton of information. One question from myself as you were going through this: when a subcontractor signs you were saying when they sign a contract that says that they may not get paid from the general contractor, how much power do they have to not sign a contract like that? Would you advise them to not sign one like that?
Well, on the typical job, it's a question if the general contractor is really drawing a hard line. You say it may be a question whether you want the work or not. There are exceptions to this. For instance, on a public works job, we have something called the listing statute, which requires that going into a bid, a general contractor lists the major trades, HVAC, electrical, plumbing need to be listed, and they need to say, here's who you're going to use on this job. So in that instance, it may be before signing the contract, they say, hey, you can't get rid of me. you need me on this job. We don't do work on a pay if paid basis. And you'll see what sort of response you get. I mean, I think when you're dealing with the real large generals, I think I would say the vast majority of them say, nope, we do our work on a pay if paid basis. But as you get to smaller generals, they are probably not, in my experience, not as strict on this. So it may be a question: do you want the work? If you're working on a pay if paid basis, like I said, be very mindful of lien rights and things of that nature. And there's always, for instance, if a general contractor's own conduct which deals nothing with the sub, causes the failure in payment, I can certainly see instances where a sub is still coming to me saying, Ryan, how do we bust through this pay if paid provision? And I think there are some arguments, not a huge body of strong case law, but where there is truly no fault on the part of the sub, the general just bungled the project. And let's say this was a drywalling sub that came in, did his drywall work with no problem. They're just saying, yeah, sorry, we messed up, so the owner's withholding payment. There's perhaps arguments to argue through them, but they may or may not be that strong. But I think when you truly have the innocent subcontractor, who was not the cause of the owner's payment failure, there are arguments to be made in court that you can try to bust through it. And at the same time, it's important to understand, hey, is it a pay when paid clause or a pay if paid clause? Does it include that magic language where it says it's a condition precedent to payment? Because, for instance, I had a client come to me a year ago to look at a contract. It had a pay when paid clause or something that didn't have the magic language. It was an Oregon general contractor who started doing work up here, and they had a different status of the law in Oregon. I absolutely left the language alone, knowing that, hey, this language is not going to be a major problem in the end because it's doesn't contain the required pay if paid language. Thus, just completely left it alone because we knew more than they did and knew they were not. While they were perhaps doing all that was allowed in Oregon for the type of, as they were used to doing on their normal public or private works jobs, they were not doing as much as they could in Washington. My point being, it's important to know what you're looking at and saying in negotiating these provisions. So,
and if a subcontractor, or even if the owner is not going to pay the general contractor, is it the time period that's the most important because they only have a certain amount to place a lien against it?
Yes. I mean, what becomes a little confusing, if the owner has not paid the general, you have a pay if paid clause. I would, as a subcontractor, still go ahead and file the construction lien claim. Technically, I mean, the general is going to defend that claim saying, hey, you only have a lien for your contract price. Your contract price is zero because we have a pay if paid clause. And at that point, the very likely advice, depending, each case differs, would be to go ahead and file the lien, and we are going to come up with an argument such as the sub did nothing to cause this, to try to bust through this pay if paid provision, or argue, no, our contract price did, notwithstanding the pay if paid, we have, another argument may be our lien right is independent. Yes, we have a lien for the contract price that's not impacted by the pay if paid, and we can still foreclose our lien directly against the owner and fight this battle ourselves. So that may be, I'd have to think through my exact arguments, but that would be the recommended course of action.
Okay. Okay, that's helpful. I don't have any other questions. Myra, did you have any questions? Not to call you out.
I feel like I maybe totally missed something altogether because I'm confused by the fact that, we are oftentimes, I work for an electrical contractor. And so we're the sub on a lot of, like residential remodels. But when you're filing the lien, it's on the owner, right? So it's not the GC. So why does it affect, I'm confused about that. Like, we have to send the lien to the owner, not to the contractor, right?
That is correct. The obligations to send it to the owner. I'll typically CC it via certified mail to the contractor as well. And I'll note something we did get into: electrical contractors do not need to provide that notice to customer. That's one exception. And the reason being that electrical subs or contractors are governed under RCW, I believe it's 1928, if my memory serves me correctly, the Electrical Contractors Statute, and not RCW 1827, which is to all other construction contractors. If you are working as, I've seen electrical contractors maintain both licenses. If you maintain a electrical contractor's license as well as a general contractor's license, which I've seen electrical subs do, I would go ahead and provide the notice. But that is one situation, one trade that may get out of that notice to customer. So
we don't have to provide, we don't have to send the notice of lien to the customer, it's to the GC. So I described two separate, and are you typically working as a sub tier, or are you directly contracting with owners in most instances? I mean, it varies, but I would say that most of the time that we're looking at sending a lien, it's through GCs. Like, we're working through the GC and not directly with the customer. Yeah.
So in that instance, if are you working on new construction or owner occupied residential remodels?
I would say more often owner occupied, but sometimes maybe occasionally new construction.
Yeah. So on the owner occupied, you're going to want to do, that's when you need I was talking about two separate notices, one being the notice to customer. That applies only to the registered contractors, which you are not, you're a registered electrician. The notice to owner, which applies when you're a sub, applies to everybody, and you would need to send your pre-claim notice before. And I would just get in the practice of sending that on all jobs, because
right.
If you're typically, I mean, it's an easy habit to get into when you start your jobs, sending that. You can set up a form that goes out at the beginning.
Is there a minimum amount?
Yes, on residential, it's anything over $1,000.
Over 1,000. Okay. So, I mean, like, our problem is that we haven't been in practice of this. And so mostly it hasn't been problematic, but we just need to make this a practice, which is why I'm here. But it's all confusing to me. It's a little confusing.
No, it absolutely is. Very few people kind of do it correctly, and, that is one of the, there's so many places to misstep in terms of and it's always better to err on the side of sending your notice, I would say, in the event that it is required. And I'll tell you, on the other side of this, if you don't send your notice, it's not often people actually get to a construction, or particularly an owner-occupied residential remodel, who knows what they're doing. I mean, most residential builders, unless you're dealing with a large-scale builder, they're not talking to people who know these statutes. So, I mean, if you came to me, I'd say, hey, you have a problem. You can't lien if you didn't get a notice when required. But the, practical reality is you're probably already coming in with more knowledge than the people you were dealing with on those types of jobs.
Gotcha.
So
is there a place that, where can I find more resources to read up on this too? Just
let me check, because I haven't checked recently to make sure we have all sorts of stuff on our website. We have a blog which is linked on this slide right here too, that talks about all sorts of construction law issues, which I'd encourage everybody to sign up for. But I need to see if we used to have more resources and forms on our website, and I need to go look. But if you send me an email, I'll check and let you know what we have. I'm not sure that we maintain them at the same level as updating them with statutes, changing everything else kind of became a burden. And but that's so beyond that, I don't know. Department of Labor and Industries and other outfits may maintain stuff as well, but you can certainly ask me questions if you have more specific examples that you're looking for. So
okay, thank you.
Yeah. And we'll have this recording on our website. And Ryan, I may work with you to get some one-pagers, see if we can put it with it as well.
Absolutely.
Perfect. All right. Well, Ryan, thank you so much for your time today. Myra, thank you for joining us.
Thank you both, all of you.
Thank you.
Yeah.
Yep. All right. Have a great rest of your day.
Okay. Take care.
Bye.